For those who don't recall or haven't done them in a while, what is an Anton pillar order? Anton pillar order is often called the civil search warrant. It entitles a party to force their way into an opponent's premises and search for and seize material that's potentially relevant or relevant to a piece of litigation. When is it available? It's available when you meet the requisite test, but the core of the test for an Anton pillar order, given its severity and its intrusiveness, is there a demonstrable danger on the evidence that important data or evidence that's important for the litigation is going to be destroyed by the defendant party if it isn't secured on the basis of a court order that's obtained without warning. Tiffany, I want you to talk about Norwich orders for a second so we can frame it.
So a Norwich order is another civil remedy that's available. And this is a remedy that you would seek in a situation where you want to commence litigation, you've been wronged, but you are missing important information that's necessary to commence the litigation. So an example would be when you don't know who the wrongdoer is. So the Norwich order would allow you to get that information from a third party that has the information. The third party has to be somehow involved in the acts complained about, and it has to be the only source of practical source of information.
So Anton pillar orders and Norwich orders alike, but let's start with Anton pillars, have proliferated and increased in number, and that was recognized as far back as 2006 when I think still the leading Supreme Court case on the issue was decided, the Celanese case. And the court observed that the supposedly exceptional remedy of the private search Anton pillar order was becoming fairly routine due to then already heavy dependence on computer technology in which documents are easily deleted, moved, or destroyed. That's continued to accelerate in recent years, and that maybe becomes a bit obvious when you think that Celanese comes out in 2006 and it was in 2007 when the first iPhone is released. There's a number of important professional and practical considerations that come out of this and that overlap with Norwich, but let's speak about the increase in those a moment as well.
So for similar reasons, Norwich orders are increasing in frequency. This is just because it's easier now than ever to commit wrongs anonymously on the internet. So defamation cases, the publication of private, like intimate photos on the internet, and there's a need to find out who that wrongdoer is and get that information from third parties.
All right. So what are some of the challenges that are being exacerbated these days in dealing with Anton pillar orders? It's become routine to image, not just one computer, but a series of computers. If it's a business premise, it's become routine to image smartphones, network servers, and external storage devices. This leads to an increasingly massive pile of data that ends up on the lap of the lawyer who's conducting the Anton pillar search. It gives rise to an increased need for work by the independent supervising solicitor. An independent supervising solicitor is a condition that comes with the Anton pillar order. One must generally be appointed to supervise the execution of the order, make sure that only proper things are seized, whether they're physical or electronic, and generally ensure that the court order is followed with integrity by plaintiff's counsel, who often are very, very excited to see just what it is they can haul away. In the context of the proliferation of data and data sources, the role of the ISS in acting effectively as a referee has only increased. Often what happens is when materials are seized in an Anton pillar, the rational defense move, the common defense move, is to claim privilege over literally everything that's taken away. That's all the more the case with respect to electronic devices, where you might have no idea what is actually on the devices that are being imaged. And so the devices are sealed, the data is effectively sealed until the claims can be resolved. Well, who resolves those claims? Typically, in cases now, it is the independent supervising solicitor who has to do the first instance review and adjudication and recommendation to the court of what is relevant, what should go to the seizing plaintiff, and what ought to stay back, whether because it's privileged or more and more simply because it is sensitive personal information, photographs, all sorts of other stuff that people keep on their devices. And that has increasingly demanded ISS to develop the ability to design review methods that are responsive to the situation of huge volumes of electronic data. The method of using keyword searches and reviewing everything that pops up, or a brute force review of all the data, are no longer as effective, simply because they slow litigation down to the point of ineffectiveness. I've started to recently try to take an approach where possible of what I call a user-facing review, where you really simply go into the device or the image of the device as though you were a user, turn it on, and look around the computer the way you would if you were an ordinary person, as a more effective way to actually get to the relevant stuff. But this is a developing area where these techniques remain to be fleshed out. Usually an e-forensics expert is going to have to be involved at least to do the imaging. But in order to properly supervise that person through the process, ISS increasingly has to develop and maintain currency in the technical issues involved, to be able to supervise properly, to be able to design sensible and proportionate search methods that don't involve keyword searches that give you 80 million things to review instead of more manageable 80,000, and to keep the document load and the expenditure of money and time in check. And I'm just going to jump past some of the examples we've had. You can imagine the departing employee cases regularly involve this. The bigger and more difficult ones involve two corporate entities against each other, where ultimately you might be looking at a corporate server that services 20 or 30 more employees. Catalyst Capital is a case that we were involved in that involved exactly that sort of problem, where the allegation was a departing employee had brought some commercially sensitive data about a bid for the then on the block Wind Mobile over to its competitor, and that involved a potentially massive review process. Tiffany, what are some of the challenges that Norwich orders are encountering?
So this is Norwich orders pose fewer challenges. It's a simpler tool, but there are some issues. It doesn't solve problems of jurisdiction hopping defendants or defendants who just change their identity to avoid detection. There's also cost implications in the sense that you might successfully get a Norwich order and obtain some information, but it's actually not sufficient to take the litigation steps that you want to take, and so you have to bring another order, and that's something that you have to weigh with your client. The Google case that Andrea referred to earlier does respond to some of these concerns. This was a case involving a small tech company that alleged that another company had unlawfully used and sold its intellectual property on the internet. And the plaintiff had obtained some injunctive relief. They had an order that the defendant wasn't to carry on business on the internet. Google had also agreed to de-index certain web pages belonging to the defendant on google.ca, but this was proving ineffective. So, the defendant changed jurisdictions. They would move the content to different web pages whenever it was de-indexed, and then of course there's the problem that most of the sales were outside of Canada's jurisdiction, and so that really wasn't very effective. So the plaintiff sought an order stopping Google from displaying any of the defendant's websites on its search results worldwide, and was successful in obtaining that order. And the Supreme Court upheld that injunctive relief. So this is a pretty interesting decision. It's confirming that courts can grant these worldwide injunctions against third parties in circumstances where they have jurisdiction over the third party. And it's going to be a useful tool going forward.
Let me just speak for a couple of minutes to some of the future challenges we see increasing or coming. One of them is just that whack-a-mole behavior by wrongdoers who can find relatively easy ways to hide or move about on the internet. This is going to be exacerbated by the availability of anonymous currency like Bitcoin to actually conceal the commercial activity itself, including its details. The existence of underground web networks like the Silk Road famously was one that's shut down. There's new ones, and we probably don't know their names right now. There will be a need for more innovation in terms of the effectiveness of Norwich orders and the procedure needed to get one, and to get a second round of one and a third round of one if you need it, as well as multi-jurisdictional or orders that are binding in a multi-jurisdictional sense, like in Equistook and Google shutting down the listings from all of Google's different national and its top-level.com interface. We're likely to see more of the same in terms of data proliferation, leading to at some point insurmountable technical challenges in an Anton Peller context. Increasing diversity in where information is stored and how to get it in the context of a search when you have entire businesses run off of a cloud with no physical location at their premises to go and seize. As well as in removable media, which have been around for a bit longer, but large-scale removable hard drives and so forth. We're going to see an increase, I think, in the need for technical expertise to decide what's privileged or irrelevant and should be kept out of the litigation for non-privileged reasons, how to conduct an effective review of that within some kind of reasonable time frame, and it's going to become more challenging to be a well-informed ISS that can manage that process with respect to electronic devices where more and more, if not all of the relevant material is now to be found in most business environments. And it's going to be a challenge for the civil justice system that is going to require the judiciary to develop the technical expertise to understand how data is stored in different apps, for example. It's not just in Word documents and Excel spreadsheets that look like documents. It's in platforms that are fluid, dynamic, and mobile. And you need to understand those to do the ISS work, but you need to understand them at the judicial level in order to adjudicate those arguments and adjudicate those recommendations. Timelines, again, are another thing that are going to be a big deal, I think, in terms of the ability to actually keep cases like this manageable in the civil justice system. And I think at some point, full reconsideration of the discovery process and our notions of relevant documents and how to get them exchanged in order to get to a proper state for adjudication are going to face a real challenge in this new world. But this is where we're seeing it now, and I think that's it.